Welcome everybody to today's July 2nd, 2026 Minnesota Public Utilities Commission. Preemptively, happy July 4th, everybody. But before we start our business for the day, we'll take the roll of commissioners. Commissioner Partridge.
Here.
Commissioner Hom.
Here.
Commissioner Tuma.
I'm here.
And I am clearly here as well. A quorum is present. We have 5 items on the agenda for today, and we will start first with Ms. Brown-Huss, if you would introduce the matter.
Good morning, Chair Sullivan and Commissioners. Item number 1 is Docket E002/C25435 in the matter of formal complaint of Hennepin County, Minnesota against Xcel Energy under Minnesota Statute 216B.164. The question before the Commission is, should the Commission investigate the formal complaint and request for relief by Hennepin County against Northern States Power Company doing business as Xcel Energy? Late filed comments were received from Xcel Energy and Hennepin County and distributed to Commissioners. Wednesday, staff filed revised decision options. Hard copies of those compiled late filed decision options are available in the back of the room. I have no further remarks, but I am available for questions. Thank you.
Thank you much. If parties would come forward, and we will quickly do introductions. We do not have opening statements planned, so we'll move directly to Commissioner questions. And I'll just start on my left.
Anne-Marie Curtin with the Minnesota Department of Commerce. Assistant Commissioner Lieb is also available on WebEx.
Thank you.
Curtis Zahn, General Counsel for Minn on behalf of the joint solar parties.
Right.
Morning, Mr. Chair, Commissioners. Ian Dobson with Xcel Energy. Oh, sorry. Online, we also have Jim Denniston.
Good morning, Mr. Chair. Todd Guerrero, QTAC Rock here on behalf of Hennepin County.
All right. Let's start with Commissioner questions. Commissioner Tuma.
Yeah, let's just kind of, we'll get to the discussion about whether we have jurisdiction and investigate, but let's just assume if we go that route, what would be the appropriate process? And so I think most of the things that were swirling around late.
Oh, we have Ms. McConnell online too. If she. Oh. Hi, Ms. McConnell. If you could just introduce yourself.
Thank you, Chair Sullivan. Erica McConnell, attorney with the Environmental Law and Policy Center, here on behalf of ELPC and Vote Solar.
All right. And is there somebody from the League of Minnesota Cities on as well?
Yes, this is Paul Merwin with the League of Minnesota Cities.
I think I see Dr. Lieb is online. Dr. Lieb, if you just want to introduce yourself really quickly.
Morning, Commissioners. Sydney Lee with the Minnesota Department of Commerce.
And there's Mr. Dennison, too. I just want to get this all out of the way so we don't miss it. Yes.
Yes. Thank you, Chair Sullivan. Jim Dennison on behalf of Xcel Energy.
Great. Okay. Commissioner Tuma, sorry about that.
Well, no, it's good to get that out of the way. We don't have to sit there and remind people to introduce themselves. So a lot of the swirling around was process. I worked with staff to try to, I think, streamline a little bit so that we can move through the process efficiently. It doesn't seem like we need to go through all the rigmarole of service if Xcel is okay with waiving the right for service, and we can just dive right into it. And then so that's my first question. You okay with waiving service as suggested in decision option 8?
Mr. Dobson.
Thank you, Mr. Chair. Commissioner Toomey, yes, we're fine waiving service.
And then we would dive into figuring out, their answer time frame. How long would you want? We had this debate about doing after the order and whatever, but sometimes I just find it easier if you just select a date that you say, I'm going to have the brief done. And if you want an extra couple days, or you think you're ready to roll and you want to do it in 2 days because you're in a hurry, you can pick a date that you want to do your reply, but then kick it to the executive secretary, Ms. Brown-Huss, to kind of figure out a schedule, working with with Sasha to figure out what makes sense, and that way it can allow for parties to intervene. If we need to have more comments after parties intervene and give comments that you want to respond to, there's just room for that activity as opposed to setting a hard schedule in it. So first to the company, are you okay with that general strategy? And if so, when would you like to do your initial
Yeah,
answer?
Mr. Dobson.
thank you, Mr. Chair, Commissioner Tuma. Obviously, we saw decision option 8 come in. It's not our position, but I understand if a decision option comes in. We talked with Hennepin County yesterday. I think we do have. I don't have it with me, but I'm sure Todd has it, and I know Jim has it. We kind of worked out what a schedule could look like. We're happy to, sort of read that off to you now, or file something in the next.
Yeah, I think
day or
for
two.
us at this stage, just the first 2 filings are what's important,
Sure.
and then you guys can, work
Yep.
work with the staff on
Yeah,
laying
we
that
have
out.
those. We can get those to you.
So what were you thinking of the first date?
Mr. Guerrero.
Mr. Chair, we were thinking tentatively that Xcel would file an answer on file an answer on July 27th. August 17th, the county would file its initial brief. September 8th, Xcel would file its initial brief. September 18th, the county would then file a brief in response to Xcel. September 28th, Xcel would then file. And then October 12th, we were thinking that other parties in general would have the opportunity to file briefs in response to the parties or the primary parties brief. You raise a good question, Commissioner Tuma, that if other parties file after the primary parties have filed, we would want to preserve the opportunity to respond to other parties. So we didn't get through all of it. These were tentative, but we thought that those made sense given the summer schedule as well.
I think that fits. That's a good schedule. Like I say, the flexibility is what we want to make sure that, either you guys can move quickly, expeditiously. We want to be able to give that opportunity, or if you need some extra time to respond to the scenarios and facts that are laid out. So that helps me, Mr. Chair. For discussion purposes, I'm comfortable finding, that we do have jurisdiction and we should investigate. That's 1 for, I think, moving TUMA 8 with the dates suggested by the parties makes good sense. We threw in TUMA 9 just because I wanted to keep the focus on the initial filing on the question at hand, not start getting into costs and stuff like that. Because typically we could probably handle that afterwards if we go down this road and by a compliance filing with some sort of negative checkoff or something, hopefully at that time. But we'll see what that looks like when we get to the end of the initial filing. So that's kind of where I'm at as far as this. I don't know if we need to have a great deal of discussion on it. I think the record is pretty clear. So that's kind of where I'm at.
So do you want to just make a motion, or other colleagues?
can I
Commissioner
make a
Partridge.
Sure. I didn't want to stifle questions, so that's why I didn't make a motion yet.
I fully support where you're headed, Commissioner Tuma. I just had a question for the order writers and maybe for others. Do we need to have those dates that Mr. Guerrero provided in the order, or how do we plan to do that? And if so, I got lost in writing them down.
So just the first 2 dates would need to be in the order,
Okay,
and that is
the
the July 27th and the August 17th.
Perfect.
Commissioner
Got it.
Hom.
Thank you, Chair Sullivan. I think everybody said this is a legal issue, but I think to me it's a substantive issue for the ratepayers. Underlying discussion on this is if one way of paying this customer is better for that customer, remaining customer has to pick up the check. I think to me this is about that discussion in addition to legal issue, because under the law, certain small distributed energy generator should be paid at the net metering. But I think essence of this discussion has to be what is the potential impact to the remaining customer? I think we shouldn't forget about this. So I'm going to ask Xcel quick questions. So one, Mr. Dobson, so if it becomes net metering versus avoided cost, one way or another, does Xcel get any extra penny out of it?
Mr. Dobson.
Mr. Chair, Commissioner Hom, it's whatever the cost is a pass-through for us, so we don't
If the final decision is higher rates compared to among those two, that we decide to go more expensive route, that difference between the low cost and higher cost will be borne by remaining customers.
That's correct.
Okay, thank you.
May I respond?
Mr. Guerrero.
Mr. Chair, Commissioner Hom, I appreciate that there are implications potentially with respect to effects on rates overall in any docket. I would suggest respectfully that rates are not germane to this question and not germane to our complaint. We have filed a complaint under existing law that allows for a specific rate to be paid for net metering projects. I would suggest to the extent that those that rate that is allowed under the law creates some sort of subsidization or cross-subsidization, that's an issue that either the legislature or this commission should take up in a different docket. So respectfully, I would disagree with your conclusion that this matter has anything to do with rates other than the rate that the county is entitled to under the law.
Commissioner Hom.
Thank you, Chair Sullivan. Yes, that's why I said we are discussing about the law, but I was telling everybody we shouldn't forget about the consequence of it. I understand there's a law. So if law allows, you should recover that at that rates, but still there's a consequence. So my point is not about this overall discussion of this docket itself. Always we have to be mindful when we are making that decision. There is an impact to the remaining customers. So I don't disagree with you on the legal issue.
All right. Are we ready?
I think so, unless there's a question. So, Mr. Chair, I would move.
Commissioner Partridge wants to go.
I just can't help myself. I just have to take 1 minute here.
She had that contemplated look, but I was thinking about, docket item number 6, but
Well, that's what I'm thinking about too.
But we got to go till 12:30 anyway, so we got time.
Commissioner Tuma, we've got a lot on the agenda here, but I do want to say, I know that we're not talking about the substance of this, but I cannot help but express my extreme annoyance and frustration at the fact that Xcel spent all this time working with the county to sign contracts, and within 3 weeks decided that those contracts were no longer valid. I know that you'll develop that, but being that we are bringing up some of the substantive issues, I just was astounded at that behavior, and I'm sure we will hear more about it, but you have a lot of people working in your legal team who work, I would assume, on developing contracts that fit the policies that you believe are relevant, and so you should make sure that those contracts have the clauses in them that you believe are relevant to the policies that you want to implement on the front end, instead of deciding 3 weeks after executing a contract that you're not going to honor it. Anyway, that's all I wanted to say. Happy 4th of July. Happy Taylor Swift wedding. Happy USA World Cup. We're moving on, and that's it, folks.
That's right. We are moving on, aren't we?
Now I'm ready to vote.
I can tell from Mr. Dobson's facial expression that he wants to jump in on this right now. That's okay. I'm going to cut you off. You don't need to. Okay? Let's hold your horses.
Yeah. So,
all right.
Working off the list of compiled decision options, I'll move decision option 1 for Tuman New 8 as modified, with July 27th being the answer date and August 17th being the county's opening brief is being due, and then also Tuman decision option 9. And I'll weigh in just a little bit. There is definitely a legal issue, and I've dove into the statutes and the rules, and to say that there a little muddy to look through would be an understatement. And probably the mud would probably sue me for defamation if they found out I said that. It is a challenge, and I see issues with how we, can use the term QF in places where it really meant net metering. And reading the statute, I'm tending to see that there was an intent by the legislature to create a separate thing other than QFs. And so that's where I'm sitting right now, reading this closely. This is not me just driving down and looking at the solar sites. This is talking to legal and working through this. What it is very factual in nature, though. We need to know the facts, and even under 216B 164, it is a very factual driven thing. I thought when I first started reading the statute, kind of got excited because in definitions, reading through it, talked about aggregated meters, contiguous property, defined what a customer was, designated meters. I thought, oh boy, they're going to create this, clarity for me, and they did create the 120% rule, and I think that's what we need to recognize is the limiting factor that's limiting this and trying to address the ratepayer impact. Whether it does or not, that's another difficult question. But there's a lot of facts even around that when you see it used in the statute itself. I think convincing me a lot was when you looked at how it talked about aggregation of facilities for the metering, the aggregation meters under 4A. It was clearly, when I got to that, it was like we're giving the customers lots of choices to how they do the meters. And so there's a lot of series that we have not addressed in the past. I'm just not convinced that we went all the way to say the 1 mile rule applies to this statute. So I'm intending to see the statute in the light that was presented to us. I just say that just so that the parties can have a discussion. I am one of 5. Okay, I was asked to dive into it and do the motion and read through all the prior things. It was very clear that Chair Sieben, when she made the motion with the United Healthcare, when you were intervening, was saying, look, you have a process, you come and file a complaint. And so that's why I don't think an investigation at this time is fair. We specifically told Hennepin County, file a complaint and let's address this. And because it is very factual, we're in our very quasi-judicial state, we're going to probably set a precedent here. We get that, and so I think the message is to others that may want to weigh in, they should weigh in at this stage. But I don't, given the facts, if the facts are as you laid them out, when you lay them out and certify them in front of us, I don't know if we'll answer all the questions. We may answer a question, and so that'll be the challenge that we have to grapple with. I don't think we're going to clear the field here, and so, but we should address this complaint and address it in an expeditious manner, because that's what we promised to do, and we like to keep our word. So that's why I did the motion, designed it the way I did to try to create enough flexibility, but also to allow for it to be handled expeditiously. And so I appreciated our legal staff helping us get to that point.
Could you repeat the motion really quickly?
Yeah, it's a decision option, working off the compiled. It's 1-4 Tuma new 8 with the dates July 27th for the answer and August 17th for the opening brief from the county, and then Tuma new 9 limiting the scope just to the questions of the 1 mile rule. Awesome. Contract and the tariffs. I mean, it's not just the 1 mile rule, it's also the tariff. We got to make sure that's applied correctly too. So,
all in favor?
Aye.
Aye.
Opposed? Motion passes. Thank you.
Good call.
You know I was messing with you. All right, on to our second item. Mr. Warloba, if you would introduce the matter.
Good morning, Mr. Chair and Commissioners. Action number 2 is docket number E002/AA24-63 in the matter of Xcel Energy's petition for approval of its annual automatic adjustment charges for the period of January 2025 through December 2025. The question before the Commission is should Xcel Energy's 2025 annual fuel and purchased energy charge rider true-up be approved. There were 2 late file new decision options and a revised decision options. Copies were distributed to commissioners and there are copies at the front over here. There is one correction that I'd like to make. It is related to Commissioner Ham's new decision option 11. Currently, it reads as require Xcel to provide in its next annual filing an analysis of why it has consistently recovered costs from 2022 to 2025 and what is being done to mitigate this pattern and the adverse effect on ratepayers. The correction there is the word recovered should be over recovered. The parties are available and staff is available to answer your questions.
Thanks. Could you, I'm looking at Commissioner Ham's decision option here. Mr. Warloba, could you show me where could you?
It is one of the late files.
Oh, okay.
It's option
okay.
11.
July 1
July
at 4:10 p.m. So there's 2 different.
Okay, that's why I'm confused. Okay, I got it. Thanks. All right, we will move to the parties introducing themselves. We'll start with the department. Ms. Campbell.
Good morning, Nancy Campbell with the department, and with me virtually is Kwang No.
Good morning, Mr. Chair, Commissioners. Ian Dobson with Xcel Energy.
All right. Okay, we'll go to Commissioner questions. Commissioner Ham.
Thank you, Chair Sullivan. So let's start with the easier one. So do you have any concern, Xcel and department, do you have any concern with additional decision option and a modified decision option I proposed?
Mr. Dobson.
Sure. Thank you, Mr. Chair, Commissioner Ham. We don't, I think, obviously with 11, if there's some sort of implication that we've been doing something wrong, we don't agree with that, but we're happy to give you that analysis of I think directly what you're asking for. As I see it, it's sort of an overall question of our forecast methodologies, since that's what would drive either an over or under recovery, but happy to provide it.
Okay.
Commissioner Ham.
No.
Oh, Ms. Campbell.
And just to be clear, we're doing it on all the new decision options? Okay. So for 11, I think like Xcel, we're fine with hearing their response to that concern for the over-recovery. For the FTRs and ARRs, why we appreciate that you did order that already. You ordered it in November 13th, 2025, order in 2563. So as a result, the department already did that analysis in the comments that we just filed on June 30th. So I don't think that's needed. We're already doing that, and it's already been ordered. And then,
Ms. Campbell, do you think a 1-year analysis is good enough, or don't you need every year we have to do it until we resolve this congestion issue?
Ms. Campbell.
Yes, I agree with that. But the first year we'll be doing it is for the 2027 fuel forecast. And so when you say the next one, I assume that's the ongoing one, the 2027. And yes, we'll need it for the future, but I don't think you need to do it in this docket in the 2025 true-up. To me, it doesn't make a lot of sense to do it in the 2025 true-up, but we do plan on doing it going forward from 2027 and beyond.
Commissioner Partridge.
This is for Ms. Campbell and probably for Commissioner Hom. Would it be helpful, one thing I noticed about these is, given that we'll want this information at least for a while, should we change this to just say, provide the following information in annual filings or in future annual filings, just to make it clear that we want this going forward, and that way if we forget it next time, it's settled?
Ms. Campbell?
I agree, that's fine. I mean, it's starting in 2027, so 2027 and forward, if you want to keep doing that, that's fine. And then I do have a comment when you're ready on the Riverside plan.
Commissioner Hom?
Thank you, Ms. Campbell. The reason I put this in here is sometimes we do the consent approval of the forecasted AAA. That's why I think the true up section might be better placed, because usually it cannot go to consent, right? Because we have some outstanding issue, and if you don't agree with Xcel on the certain denial or the additional recovery discussion, we can also stay in the more open discussion rather than sending it to consent. I don't know whether that 2027 forecasting for 2026 year, so which you just filed a comment, I quickly reviewed that one too. Now, this time, that is in there, so probably we have to do full-blown discussion, but I think last several years, we are doing some of those consent approval on this AAA. So I was trying to figure out which time, forecasting or true up, where is a better venue to discuss this issue. So yes, I understand it's very confusing because we are using same docket number for the forecasting ahead and then true up later. So which docket you prefer, and you can consistently provide that analysis?
Ms. Campbell?
Sure. I guess my point is, it's now starting in the 2027 fuel forecast. We'll probably have to do a follow-up as part of that in the 2027 true-up too. I mean, it could be that we end up doing nothing. It could be that we end up adjusting the forecast. It could be we end up doing something at the true-up stage for rate recovery. We don't know that. So to me, it's going to happen in both the fuel forecast and the true-up, but starting in the 2027 fuel forecast going forward, if that makes sense. So that's why I don't think it makes sense for this docket, because it's the 2025 true-up, right? So.
Mr. Dobson, did you want to, because you were going to say something before, but I was just managing traffic, and I want to make sure you got to say what you were going to say.
Sure, Mr. Chair. I don't think I have any disagreement to what Ms. Campbell said, but I could tell Commissioner Hom was going to ask a question, so maybe that'll change it. Who knows?
Okay, so in this docket, we are approving true up for the 2025 year, and then we are going to true up the 2026 year in the 25 dockets, and then we are going to discuss that 26 docket for the 2027 forecasting and on. So are you suggesting that we should forget about what happened in 2025 and 2026 in congestion side? Or that's why I was saying that 2025 true up is our current docket. Shouldn't we make Xcel accountable for the 2025 action or inaction? So to do that, we have to do that in this true up docket rather than forecasting docket. I am just wondering why you think that 2026 docket forecasting for 2027 is the right venue to do it. In that case, we may not be able to go back and do the 2025 and 2026 congestion issue.
Ms. Campbell?
I guess since we're doing it for the first time in 2027, that was my expectation, is that's when you put the companies, the utilities on notice, and you do it going forward. Otherwise, it tends to get a little messy, and I would consult with your attorneys, which I am not. But there could be an argument for retroactive rate making or something like that, legal issues. So that's why I think it's a lot cleaner to do that. Like, I think we agree that there may be an opportunity to do better on the FTRs, ARs, but it hasn't been proven yet. We're still evaluating that. So I would say doing it in 2027 forward is probably the most appropriate.
Are we trying to get a baseline, Commissioner Hom? Is that, I mean, I get what she's saying, we're maybe not doing anything, we're not gonna probably do retroactive making, but getting a baseline and understanding what's happening, I don't know if that is part of the information that we're gonna be gathering in the future, is what has been the baseline, what have we been doing for the last years?
Yeah, okay, so I'm not a lawyer, so but I have a different opinion. This is about true-up. True-up is not a retroactive rate making, right? In the rider, we have a right to adjust any recovery. And then that's why we are discussing Riverside and everything in this docket. That's why I said this is the right docket to discuss it.
This is about jurisdiction, so.
Yes.
I got it, okay, so it's not about historical, it's about this, we got jurisdiction, let's take a look at it, okay.
Ms. Campbell?
I'll just say one more thing. I mean, we don't have the record here today. We're deciding the 2025 trip today. I don't think you have a record right now to deny FTR costs. I feel like I'm fighting the utilities fight on here, but I think it's only fair that we do it 2027 forward, but you can certainly do whatever you choose to do. I do agree it's rate subject to refund, but usually once you approve the 2025 true-up, you're done, and you don't usually reach back unless you've preserved it, like we're doing for the Riverside plan. And if I could, can I weigh in on the Riverside plan, or do you want to wait to get to that?
I'm going to let Commissioner Hom respond, and then we'll go to Riverside.
Yeah,
Hom.
that's why I was very disappointed that record wasn't developed in this docket. I think this issue was raised for multiple years. We had a very thorny discussion last year about department is asking commission to deny certain cost at the Noble substation issue, while department was making that statement and not developing the record in this docket. So we cannot do much. I agree with you. Without developing the information, we cannot do much. But still 2026 true-up is open. And then year 2026 is not over yet. So we still have an ability to develop more record in 2026. But now department is suggesting that, oh, we wait until 2027. So that's why I was trying to develop the record here. At the worst, we can deal with it in 2026.
Ms. Campbell?
We can certainly attempt to try to do in the 2026, but you're right, we started doing it in 2027. And if you look at our comments that we just filed on June 30th for 2 of the utilities on July 1st, you can see there's a lot of different answers. I think every single utility is doing it differently. So I don't think there's a magic answer, and I don't think we have a smoking gun yet.
Okay. Any other questions on this? Okay, we're going to Riverside next. Okay. Let's talk Riverside.
So for Riverside, I thought this was going to be an easy discussion because I thought the commission already made this decision in the rate case on the 21st. So a little confused of why we're kind of revisiting this, but respectfully, it seems like decision options, I know there's an or, but I probably would say 4, 5, and 7 all capture what I think the commission has already done in the rate case. And that is, we wanted a contested case right away, but we conceded to waiting until 90 days after the Riverside plant came back from its outage. And you gave us the ability to get an expert to help us with that. And we're going to review the purchase power costs and the capacity costs. That was my understanding of the decision. And so I'm not quite sure why you would make it a different decision here.
Commissioner Hom.
Thank you, Chair Sullivan. So when I was discussing this with our legal and then staff, I think to be consistent with the rate case decision, they suggested we have to do this. So if you have that difference, I can consult with our staff one more time before we make a decision. But I think I can do other question if this decision can be.
Commissioner Partridge.
I will just add to Commissioner Hom's statement that I also discussed this with staff, and that the distinction was the replacement power costs, that the language that we adopted, I don't think included that specifically. And so in consultation with our staff, we felt that it was both consistent to make this decision to include or to refer the Riverside outage replacement power cost to a contested case that would be consistent with how we treated the other costs that were specifically considered in order point. I believe it was 1020, and I can't remember the other one, but someone else may have it in the rate case.
And I thought we were leaving the decision about contested case in to the post
Right.
startup. So that's what was confusing to me, why we would refer to contested case at this stage.
Yes.
And so I want to make sure we're consistent with what we did. And I thought it was, let's just wait till we get to startup, and then they were going to come in with a proposal to say, we don't see there are any issues here. We're gonna refund the ratepayers X, and the department's okay with it, or there are factual issues here that we really need to go to a contested case. I was trying to leave that flexibility, was my recollection, but.
I misspoke. You're right. That's what I have in my notes, that we did not necessarily refer it to a contested case yet, and that the way I think that Commissioner Hom has it worded here in Hom Revised 6 is consistent, in that the distinction was just the replacement power costs weren't specified in our decision in the rate
So
case.
I was thinking Hom 6 was the revised 6 was the appropriate course of action, but
That's what I think. Nope.
Same. Ms. Campbell, does that make sense or help clarify that it's just this specific wording, I think, is the replacement power costs were not specified in our rate case order points, and that the rest of it should be consistent with how we treated the costs of Riverside?
Yes, thanks for that clarification. I guess I misunderstood that. I thought you had decided to do that to a contested case and give us an expert as well. So maybe we're still getting an expert. Maybe it's just not a contested case until we come back after 90 days and then decide it then.
We, as I understand it, Ms. Campbell, we did, I'm looking at staff, that we did approve your request to seek authorization for an expert, so that you are right on, but that we did not specify a contested case yet. And I just want to say I feel better that there's a little bit of collective amnesia, because I felt like I was had hit my head when I was like, what did we do? So I feel better.
Is amnesia or just the volume?
The volume of decision. Yeah.
Commissioner Hom, do you want to make a motion, or are you ready?
No, I have a,
Got some more? Okay.
yes. Mr. Dobson, what is the status of Xcel deploying dynamic line rating?
Mr. Dobson.
Mr. Chair, Commissioner Hom, I think I would ask for Jason Standing to step in for that question.
Is Mr. Standing in the room, or is he online?
I believe he's on the line.
Oh, I don't see him on. Oh, there he is. All right.
Online. Oh, sorry, it's different cameras here. Commissioner Hom, was your question?
Mr. Standing, if you could just introduce
DLR?
yourself for the record.
Oh, my apologies. Jason Standing with Xcel Energy.
Tell us why you're in a bomb bunker. I'm getting a little nervous.
That's where he always comes from when he...
It was the COVID thing where my wife works from home and she's way up in the corner and says I'm too loud, so I had to be stuck in the basement. So
good.
But I think the question was, what is their status of DLR deployment?
What is your status of the deploying full dynamic line rating? You have 2 pilots going for a while, and
we have 3, correct? Yes.
What is the current status?
Mr. Standing.
We are still in the data gathering standpoint. I did check in about a week or 2 ago with our engineer who's running the program. I think the last update I gave you, I forget when the meeting was, but we're still getting some data and we're getting some inconsistent readings from the three different vendors that we're currently evaluating. So we're still in the data evaluation and trying to square away, who's right and who's wrong. So that's where we're at.
Okay. So I haven't done this for a while, so I don't know who's doing this at your shop. Who's covering MISO Reliability Subcommittee?
Mr. Standing.
The Reliability Subcommittee, we have a new regional planner, Elizabeth Sheldon. She started about a couple months ago, so she'll be covering these along with our planning group. So I think Craig Reesley is our current reliability planner on there right now.
Is there any communication within the company about MISO top 10 congested flow gate data each month Reliability Subcommittee is discussing?
Mr. Standing.
That comes, yes. Thanks for the question. That comes through our economic development program. They do track the top 10 congested MISO flow gates, and if there's anything that comes out of that group, that it does transfer to the planning group if there's something that is related for NSP.
After you see that over multiple months, don't you feel that there is an urgency of deploying this dynamic line rating at the Xcel system?
Mr. Standing.
Commissioner Hom, I agree that we are obviously very concerned and supportive of dynamic line ratings, but we want to make sure that we're getting the right numbers. And when talking with our program manager for the dynamic line ratings, obviously the three different sets of numbers is concerning to us, that they're not agreeing with the ratings at the time. So there's been some concern about who's right. And so we just want to make sure that we're getting it right. And obviously we're still on schedule to meet it when MISO goes live with it. But, I think our big concern is we just want to make sure that we're getting the ratings that we think we should be getting.
Okay, so I don't know whether you review these dockets, but based on the information we have, Xcel Energy ratepayers losing $107 million due to congestion. So net ratepayer impact due to the congestion, after we deduct FTR, ARR revenue, there was $107 million. It went to somebody else. Do you agree, or do you know that number?
Mr. Standing.
I apologize, Commissioner Hom. I don't know that number off the top of my head.
And then
I should say our group doesn't track it.
Yeah. Do you still see no urgency in the deploying dynamic line rating even after you see all those numbers? I didn't include the $37 million, the curtailment payment you made to your PPA contract, because it's a must-take contract. So when those PPA provider or the developers are being paid not to produce due to the curtailment.
Mr. Standing.
I will say this, Commissioner Hom. Obviously, we want to push forward technology that we think is viable and useful, but we want to make sure, again, that anything we deploy or pay to deploy does have the desired outcome that we want it to and doesn't give us false readings. I think that is where some of the engineering concern comes from, and I do share that concern too. But we have in the past always been proactive with our congestion and curtailment monitoring and putting in projects to make sure that, to the best of our ability, we eliminate any congestion on our system. And I think we've given the update in the past too that we've fixed a lot of things on our systems, even paid for other people's systems upgrades to help our congestion. Dynamic line ratings obviously is a tool in our toolbox and we want to use it, but I think our engineering and operations, before they sign off on this, want to make sure that we are sure that whatever technology we choose for DLR, it's giving us accurate readings. And so obviously congestion is something we don't like and don't want to see on our system. but we also want to make sure that we don't inadvertently cause a reliability problem by getting false readings.
Commissioner Hom.
Yes, I think, do you agree or do you don't, whether we will have a more significant congestion in our area due to the ongoing transmission line construction next 10 years?
Mr. Standing.
Commissioner Hom, I would agree with that, yes. We will likely, but through our sequencing and when MISO and the TOs do their construction sequencing, we're going to work to minimize that as best we can. Obviously, take advantage of any operational options that we can, system reconfigurations, things like that, to try to minimize the congestion through the next 10 years of construction. But yes, it will likely impact some of southwest Minnesota, yes.
So given the magnitude and then projection of getting worse, and if Xcel doesn't see that as an urgency to deploy this technology, I have a serious concern that we have to seriously discuss about denial of some of these energy cost recovery. Otherwise, I don't think a company is going to get the signal, because Great River Energy already deployed their technology and they are realizing this benefit. I don't know what makes them much difference between Otter, the Great River Energy and Xcel. Why do we have to do so much pilots, given that magnitude of the congestion revenue going away from ratepayers? So yeah, that's why I say I cannot wait until 2027, because this was an ongoing problem for the last several years, and it's getting worse. And then, yeah, waiting until 2027 means we are going to lose a lot of money. Our ratepayers are losing a lot of money. Can I go?
I think I'm glad you're raising this point, Commissioner Hom. I think it's important. I mean, congestion. I remember when we used to work closely on this, and, we would go down to southern Minnesota, and the impact of congestion is not just to ratepayers, but it's to those communities that, are reliant on the production tax revenue, and in some cases up to 40% of their tax base. But to this point, I'm sure if there was, somewhere, the FDRs obviously subtract off of the congestion costs, but if there was a more than $100 million hit to earnings, I think we'd see a significant expedient, we have to move fast. Commissioner Hom.
Thank you, Chair Sullivan. So now dynamic line rating issue, I think we discussed enough, so I'm going to move on to the FTL hedging issue.
Commissioner Hom.
So yes, thanks for the department. Department filed the extensive discussion and analysis on that issue in the 2026 docket, which will do the 2027 forecasting. Thank you for the department. But unfortunately, I cannot use that in this docket because the timing of the filing, I only skimmed through it. I couldn't fully reading through all discussion, but high level, I don't know what Xcel is doing to optimize that conversion of the auction revenue rights to FTR.
Mr. Dobson.
Yeah, thank you, Mr. Chair, Commissioner Hom. For this set of questions, I'm going to ask Mark Breeze to come off the mic.
If you could,
Can you hear me?
Mr. Breeze, if you could just.
Mark Breeze, Xcel Energy, Director of Trading and Origination there. Thank you, Commissioner, for your question. Yes, I understand you can't use our responses that we've provided, but we are, in response to your prior question to Jason, we do sense the urgency here and are very aware of the dollar magnitude that is here. And in fact, in that regard, we are very engaged with the MISO stakeholder process to work on changes to the fundamental market design that would better align our ARR allocations to our actual utilization of the system. MISO's process or rules allocate our ARRs based upon a 2004-2005 timeframe which is very inconsistent with how the system is being used today. Other ISOs do not use such a historical process. Their SPP, for example, which we are a participant in through one of our utilities, uses a very current process, and there's a much better match between the returns on the ARR values and your actual congestion costs there. I'm not sure if that answers your question. Did you?
Commissioner Hom.
Thank you for that answer. Yes, I fully aware that changing this freeze date is a very difficult process at the MISO or close to impossible. And then I hope that Xcel and all other utilities are working hard to make sure that we are getting new baseline on this auction revenue right allocation process. That being said, given your allocation as of today, you are losing about $107 million in 2025 because your positioning of FTR was not, I understand it cannot be perfect, but because your FTR position was so bad, ratepayer were losing $107 million. What is your process for determining which portion of the FTR you are converting from ARR and or even procuring additional FTR through the secondary market?
Well, let's talk about
Mr.
There are
Brees.
two aspects. Thank you. Sorry. There are two aspects to that question there. What we convert and then what we go out to acquire on an FTR basis there. The conversion process is based upon what we are allocated. And we don't have a choice in what our options are there. That's the MISO process there. And our process on that is to maximize the revenue, and that's based upon historical valuation of the returns and expected forward expectations with respect to that. So what our goal is in the cap that we get from our allocations is to maximize revenue for our customers. And we can only work within what we're allocated or the options that we're given there. With respect to the ARRs, and as I think you're quite aware there, the ARRs are given to us. They're free, and so when we convert them to to FTRs, we get the value of them. And the only question there you have, Commissioner, is do you take the auction revenue value for the ARR that you are granted, or do you self-convert into the FTRs? And our approach is to self-convert into FTRs because we believe that's more of a direct hedge, because if congestion's big in a particular year, you get more return versus the ARR, which is a forecast and expectation of the marketplace there. So first part of the question is on the ARRs, our goal is to maximize the value based on our analysis of which of the ones that are allocated to us are worth money. With respect to acquiring FTRs, and this is in our responses to the next cases, we don't see that as a positive or effective means of reducing our exposure, because let's be clear, there you have to purchase at the market price the FTR. And so when you do that, you pay for that FTR. You don't get it for free like the ARRs. And then your position is, well, is actual congestion going to be higher or lower? That's a speculative position there. And the net benefit of that or cost is a function of the difference between what you've paid, that market price for that FTR, versus how it realizes. That doesn't really hedge or offset the congestion costs for the customers. That's a speculative position in the marketplace.
Commissioner Hom.
I don't agree with it. That's not a speculations, okay? So based on your data and information, you should predict what will be a congestion, and then you buy those FTR. That's the hedging. When you speculate, you favor high risk, high return, and you buy things even though your data is showing that you will potentially lose money, but because return is so high, you buy into that FTR. That's a speculation. We are not asking you to speculate. We are asking you to analyze your system. Last several years, you had a very serious congestion going on, but you think still that's a speculation, even though MISO top 10 congestion flow gate information is keep producing at least 2 or 3 Minnesota flow gates, and then actual number shows that you are net losing 100 million. I don't know whether just what you are saying is you are doing regulatory hedging, means you are not getting whacked by a regulator because you are not doing anything but just doing default. I understand that regulated utility has that behavior because nothing good can come up when you are very proactive from the regulator. I understand your concern. That's why you should actively discuss this issue with the department and bring that issue into the forecasting of your fuel clause so we can have a discussion, rather than you push the default button and saying that, oh yeah, we are not speculating. No, we are not asking you to speculate, but you have to be proactively hedged to protect ratepayers.
Dr. Lieb.
Thank you, Commissioner Sullivan. I don't know if I have to reintroduce myself. So I'm Sydney Lieb. I'm the Assistant Commissioner at Minnesota Department of Commerce. I just wanted to have because the department's been looking into this for a while now. So I want to just add from the department's perspective. I think we hear what the company's saying. I think we would acknowledge that some of the market rules are not necessarily incentivizing reducing congestion to the extent that's necessary for ratepayers. I think we're still investigating what the right practices would be, but I want to support sort of where the direction Commissioner Hahn is going, that there's definitely more that could be done here. I think the resistance to the dynamic line rating investment is odd. It's like we're saying other utilities in the state that are co-ops that don't have the same capital bias seem to have no concerns from a reliability perspective about making these investments. And I think we want to continue to work with the Commission to bring forward enough data so that we can either start denying energy cost recovery if the utility is not making the right investment to reduce congestion in a reasonable way, regardless of what the MISO market incentives may or may not be for the utility to do that.
Thank you, Dr. Lee. Commissioner Hom, do you want me to call on Mr. Brees as well? Or, I mean, I think you've said your piece. And
I'm done. I mean, I made my point and I asked enough questions. I don't think I got a good answer from Xcel. Now we have to think about what action we should take.
Mm-hmm. Does the company want to respond, or are you just taking it in?
Mr. Chair and Commissioner Hom, I guess I don't know what was implied there in terms of taking action. You've heard obviously both from Mr. Standing and Mr. Brees, and apparently we're not satisfied with those answers. I think all I would say on the higher level is we're very aware of the congestion issue and have been coming in for years talking about what we're doing. If you're concerned that we are not moving fast enough or not taking certain steps, I can say there is no hesitation from us to continue having that discussion. I think, my own view from a higher, obviously a little farther back than both of these two individuals is it's a very serious issue for the company. We are trying to take it seriously, and we are trying to lower these costs because it's important to our customers. But obviously, to the extent that you want us to be doing more or doing things faster, we're open to that discussion.
Commissioner Hom.
Thank you, Chair Sullivan. Is there any way Xcel and department can share your pilot on the dynamic line rating? And then if department we may need to allow department to hire outside consultant to evaluate those information, why Great River Energy was able to deploy their dynamic line rating right away, while Xcel is so hesitant to deploy it. I don't want to second guess your concern with the reliability. Yes, that's important. But there is some concern that maybe there is no good communication between your departments. Okay, urgency of regulatory side and urgency from whoever is doing the rates is not going to your distribution or transmission system group. And I hope that this urgency information has to go through them. To do that, I think we need more record developments. I don't know whether the department is willing to engage in more in-depth technical discussion with the Xcel on at the minimum, dynamic line rating and then hedging issue. I think I'm not asking you to change freeze date as of now, because I know it's a multi-party MISO discussion. Set aside that issue. Whatever you can do. What is your ARR nomination strategy? And what is your failure rate and the success rate is getting that? And then why you are just converting that to FTR rather than checking whether you get more revenue by offering that at the FTR market versus converting it. And then in the secondary market, why you guys are not procuring additional FTR if there's a significant congestion going on. So that all those kind of technical issues should be developed before we take any action. That is my frustration. I know the symptom. We know the symptom. Congestion revenue is going away. Ratepayers are losing tons of money. But to discuss potential consequence to it, we need to have a record development.
Ms. Campbell.
I appreciate that, and we just did a bunch of record development in the Xcel, MP, and Otter 2027 fuel forecast. We're going to attempt, I reached out, and we're going to attempt to do it for 2026 for the true-up. And I know we've heard about the dynamic line rating issue, and we will dig in and ask some information requests and see if we can't speed that along and think about the $37 million curtailment issue that you raised regarding that. So, so yes, we will work on those issues. We already started on the hedging, and we'll add dynamic line rating to our list.
Thank you. Yeah, in addition to that, loss to the ratepayers very visible in the accounting part, but the couple of things are not showing in that accounting. That is a line losses. When there's a congestion, line loss goes up. So there's a more line losses going on. And also as a society, when MISO deploy an economical unit due to this congestion for the security reason, as a society, we are losing more money out of it. So those numbers are not showing up in this discussion. So our ratepayers and Minnesota ratepayers are losing tons of money above and beyond this much money. So that's why it is my frustration. We need to develop the records. Company has to move it quickly as soon as you can. Otherwise, our ratepayers keep losing this money.
So I'm really glad that you brought this up, Commissioner Hom. I think it's really important, and I do think we, if you're ready to move on, we can. But one of the points that where my brain goes in this conversation is that, I mean, I've always thought that MISO brings a very significant value to Minnesota ratepayers, that having access to the larger market. But congestion eats away at that value. And I've asked many times, you know, can we get a number, like what is the actual number per year of MISO's value to Minnesota? And I know, I get it, it's hard to determine what that number is, how many hundreds of millions of dollars to the good it is for us to be in MISO rather than not. But these kind of numbers, this kind of congestion, what I can mostly say is that it really does significantly reduce the value proposition of MISO's, of our membership. I'm not going to say that puts us in a bad, I still think it's probably worth it, But it is, it's very painful to see Minnesotans having to pay this much in congestion revenue. And then also, like you said, that it's the knock-on effects of, increased line effect or line losses and other generators that have to run. So anyways, I'm glad you brought this up. Thank you. Are you ready for a motion? Show us the way.
So I can move decision option 1 and 2, 3, modified 6, yep.
Yeah.
And then 7, 8, 9, unless company has an issue.
Company is okay.
And then my new decision option, which is not numbered, but I think implied as a number 10, which is just, even though Ms. Campbell says it's a potential redundant, but I want to make sure that we are capturing in all the places. I want to make sure that we are capturing it, every AAA docket, to make sure that we are following it. And then HAM new 11 as modified by staff, inserting over before recovered.
All right. Motion, is the motion clear, Mr. Whitty? We're good? All in favor, please say aye. Aye. Opposed? Motion passes. Thank you. Here's what I'm just going to take a beat. Commissioner Hom, how long do you think, because you have decision options for Minnesota Power's fuel clause and Otter Tail's fuel clause, or not an Otter Tail, but an MP's, how long do you anticipate? You got it out? So here's what I'm going to do. We'll work through the next 2 fuel clause items, then we'll take a 10-minute break, and then we'll come back for the final item of the day. No, it's actually been revised. Yeah, we can go, immediately. So, that being said, thank you, Mr. Warloba. Appreciate your work on this, and thank you to all the parties. And now I think Dr. Larson is coming forward, and he will introduce item number 3. Which is Minnesota Power's fuel clause. And
they're happy they're going second.
Sure, yeah. And then, thank you, Commissioner Partridge. We are on the notice filed last week. We indicated that we're not going to hear the last item before 12:30. We have changed that, and we've talked to all the parties, and we are going to hear that before 12:30 now. So we've confirmed that that is okay with all the parties, so we are going to hear that before 12:30. Sorry if that wasn't clear before to folks. So with that, Dr. Larson.
Good morning, Chair Sullivan and Commissioners. Before the Commission this morning is item number 3, docket number E-015/AA-24-64. In the matter of Minnesota Power's petition for approval of the annual forecast of automatic adjustment charges for the period of January 2025 through December 2025. The question before the Commission is, should the Commission approve Minnesota Power's annual forecast of automatic adjustment charges for this period, January through December of 2025? Please note that there is a late filed decision option on behalf of Commissioner Hum, and the Commissioners already have copies, and there are paper copies available at the front table. Staff and parties are available for questions. Thank you.
Thank you. All right, we will now have introductions, and we'll start on my left.
Morning, Justin Taylor with the department.
Nancy Campbell with the department.
Mr. Brodeen.
Commissioner Sullivan, or Chair Sullivan, Commissioners, Matt Brodeen on behalf of Minnesota Power.
And is there anybody online?
I do not have anybody online. I have some phone friends that are providing information to me, but
Well, if you need to phone them, we will introduce them at that point. So with that, Commissioner Hom.
Thank you, Chair Sullivan. So I think Minnesota Power heard enough in the Xcel dockets. I think same concern with hedging issue. And then I know that dynamic line rating is a bit tricky for you because you are on the one side of the state facing the lake. However, still you should rigorously develop potential dynamic line rating above and beyond complying with Order 881 because that only required to do ambient adjust line rating. I know that many of our utilities are already doing it voluntarily, and then we are trying hard. However, I think overall impact is so significant. I don't know exact number in your side, but at least in the qualitatively, MP admit that you are losing money in the FTR markets, net congestion revenue going away from your ratepayers. So I didn't see quantitative number, and then there was a back and forth with our staff data request. So overall big picture is, yes, company has to proactively evaluate your ARR nomination strategy and then FTR conversion and FTR purchase strategy. Hopefully, department can engage in that discussion with you because we cannot engage that discussion with you. Legally, we cannot do that. So hopefully, department has a ability to save some time to talk with the companies to make sure that we are developing those records properly. So company is showing that you are doing your best to help your own ratepayers.
Mr. Brodeen.
Thank you, Commissioner Hom. We're open to those discussions with the department, and our folks internally are doing what they can, and to the extent they want to, much like Xcel, the ARRs are allocated to us, and we utilize those based on our best information in order to convert where it makes sense and where it saves the customer's money. And in the areas where we see congestion that we do not get allocated ARRs, we do purchase FTRs. That's a question of, is the FTR, does it cost more than the actual congestion, or does the congestion cost more than the FTR? So there is some speculation involved in that, so it's not a perfect science, but we're learning like everybody else is with all the changes that are coming in and trying to do the best for our customers and to save them as much money as we possibly can.
No, I mean, that's why I'm suggesting you to discuss that with the department to make sure that you are not speculating, but you are hedging. So hedging and speculation can be a difference between one thin paper, but I think that's why we need to have a good discussion between company and department to make sure that we are developing proper records and companies really paying attention to it. And that once again, I said, yes, regulatory hedging is the easier thing to do. You just don't do anything, it is easier for you because you don't face. But in my view, inaction should be accountable too, because your inaction can cost money to the ratepayers. So,
Commissioner Hahn, I agree, and we are, like I mentioned, we're definitely willing to work with the department on this and have those discussions.
and then also, I don't know whether you are aware that your congestion pattern has changed recently due to the Manitoba Hydro drought condition on and off last several years. So that's why, because if you are so comfortable with what you are already doing it, that can potentially cost money for the ratepayers. You have to pay attention to every year, making sure that congestion can occur if there is a drought condition at the Manitoba.
Commissioner Hum, that's correct. And that is something that we look at as far as the forecasting of congestion and based on Manitoba and our other generation assets.
Okay, thank you. So last one. So our staff, on my request, calculate your performance on this true up. Last 5 years, you under recover 4 out of 5. I think it's not, my concern is not as big as over recovery, but I think still, I think you guys need to do better job to make sure if everything is perfect, it has to fluctuate plus minus, plus minus. My concern is you are so comfortable not doing it. So that's why I want to make sure that you guys are paying attention. You are fully aware of what's going on and making sure that you are doing your best to this fuel clause forecasting so we don't have to have a lot of fluctuation because volatility can cause heartburn to the ratepayers too. Sometimes absolute level of inflation may not be as bad as a sticker shock. So if you used to pay very low price, still low price, but when price goes up suddenly at a certain percent, people has a more negative reaction to it. That's why I want to make sure that you are doing better job in the forecasting on the fuel clause adjustment.
Commissioner Hum, and there have been some changes made more recently and going forward here based on what we've learned throughout the history, the last 4 or 5 years. Given a lot of this stuff is relatively new, we're still learning as we go, but I think we're making decisions, and we typically don't make a decision based on the results of 1 year or 2 years. It takes a little bit of a pattern in order to make some of those changes because we don't want to swing wildly in one direction or another, but we have made some changes in how we address the AR FTRs beyond the data that we have in this case.
Yeah, thank you.
All right. Any additional questions? All right. Commissioner Hom, do you have a motion?
Yes, I can move decision option 1, 2, and then additional decision option proposed by me. It's the exact same language I was using for Xcel side.
Future reporting requirements.
Looks like the motion is clear. All in favor, say aye.
Aye.
Oppose? The motion passes. Thank you. Thank you, Dr. Larson. Thank you to the parties. And now let's move on to Mr. Andringa and the fourth item of the day. And if there are folks from Otter Tail, if you're online, if you could turn your cameras on, or, oh, there they are.
Wow, all at the same time.
All at the same time. All right.
Thank you again, and good morning, everyone. The fourth agenda item is docket number E-017/AA-24-65 in the matter of Otter Tail Power Company's petition for approval of the annual true-up for its energy adjustment rider for 2025, rate schedule 13.01. The question before the Commission today is, should the Commission approve Otter Tail Power Company's petition to true up its energy adjustment rider? Staff will note one correction to the briefing paper on page 11. The second paragraph, within the second paragraph, states that the total 2025 MISO and SPP credits are $62.3 million. However, based on table 11 on the following page, the correct total should be $21 million, consistent with the amount shown in the actual column. This correction does not affect any of the decision options before the Commission today. And with that, I have no further comment, and staff and parties are available for questions. Thank you.
All right, great, thank you. And we will start with Otter Tail. I see 4 people from Otter Tail. I will let you guys decide who starts first.
This is Doug Newby from Otter Tail Power. I'm a rates analyst. On the phone with me, I have Amber Grenier and Ryan Retzlaff.
All right. Everybody needs to, if they're going to plan, if they may speak. So, Mr. Grenier, or Ms. Grenier.
Good morning, Commission. This is Amber Grenier with Otter Tail Power Company.
Good morning, Commission. This is Ryan Retzlaff with Otter Tail Power Company. I'm the manager of Power Services.
All right. Okay. Commissioner, is there anybody else? All right. And Ms. Campbell.
Nancy Campbell with the department, and with me virtually is Lynn Bear.
Thank you. Commissioner Hahn.
Thank you, Chair Sullivan. I think Otter Tail is one of the examples. We have to carefully approach dynamic line rating. Okay, it's good. It might be good for the society. It might be good for the whole Minnesota. It may not be good for the Otter Tail customer. In this case, Otter Tail is making money due to the congestion, probably because a lot of those generation in that congestion area is not belong to Otter Tail. So this is a huge conundrum that whether we should order Otter Tail to improve that congestion so their customer will lose money versus whether we should improve this one for the whole Minnesota. So I think even though I was very unhappy in the initial discussion, but also I give a lot of credit to Xcel. During the Grid North Partners 19 project, they went to the Otter Tail area and fixed some of the limiter to improve congestion. Yes, so you should get that credit. So I think that there must be a more discussion among Minnesota utility how to compensate Otter Tail to make sure that they are not using ratepayers' money and ratepayers actually losing money because congestion is relieved. It might be good for the whole Minnesota, but it may not be good for the Otter Tail ratepayers. That's why I don't have a lot of concern as it is, but I think that's why Grid North Partners are a great entity that Minnesota utility get together doing planning. I think that's why I mentioned during our biennial transmission gas docket that we have to be careful not to force our utility with the dynamic line rating because sometimes it can hurt ratepayers for that company. So we have to find a way to compensate the company in different way, but I don't know how to do it. It has to be done in MISO way. But I think that's why I hope our utilities keep talking. So other than that, I have one question to the Otter Tail. So same thing, our staff calculate these last 5 years, your performance, I think you are 4 out of 5 on the recovered. So I think same concern as I raised to Minnesota Power, please pay attention to it because congestion pattern can change and also that can have an impact to your rate, the energy price forecasting for the upcoming years. And given that large load is popping out in your South Dakota, North Dakota area, so you may have a more dynamic situation, so you need to pay more attention to this change in pattern to make sure that Minnesota Otter Tail ratepayers are not being harmed by those things.
Ms. Grenier.
I think I might pass that on to Mr. Retzloff.
Mr. Retzloff.
Thank you for the question, Commissioners. To be just honest, that's going to be very difficult for us to predict, where those large loads are sited and how they'll impact congestion. If they're on the high side of a binding constraint, they're going to aggravate the congestion. If they're on the low side, it's going to reduce congestion until we fully know where those projects are going to be and have certainty that they're going to be added. Like you mentioned, it could be a big swing either way, but Otter Tail continues to monitor our FTR and ARR portfolios, and we continue to try to optimize that to the value of our customers. So you're correct in that we certainly sit in a different situation. Our historical generation does match congestion patterns. Going back to the start of the market, Otter Tail built that system, and so we're just advocating that if there are changes to the FTR structure, that it doesn't impact Otter Tail because we've always had the right to move energy from our generation to our loads. So, but continuing to optimize as best we can.
Okay, thank you.
Any additional Commissioner questions? Commissioner Hahn, do you have a motion? Yes. Or does the department want to say anything?
No, I don't think. The only thing I'll mention is the FTRs, ARs, if we can encourage MP and Otter Tail to provide those responses to us so we can complete our analysis, that would be really helpful.
Yeah, I think that's important. Thank you. So, Commissioner Hom.
So I can move decision option 1, 3, 4, 5.
All right. All in favor, say aye.
May I just add
Mr. Andringa.
Sorry, we want to add the future filings as we discussed.
Yeah, I don't know if I suggested that earlier. I'm not sure we have been doing that. I think we can, I think it didn't get captured. I'm not sure if it got captured in the other ones, so. Yeah, I think it's fine.
Throw it out there. Thanks.
Yeah, thank you.
My sense is that it's pretty clear through the conversations that this is going to come back, keep coming up, so. All in favor, please say aye.
Aye.
Opposed? Motion passes. Okay, so we will take 10 minutes, and then we will come back and hear the last item of the day. Thank you, Mr. Andringa, and thank you to everybody for working on this. And we will see everybody at 11:40. All right, welcome back. For our final item of the day, Ms. Ricker, if you could introduce the matter, and then we will have the parties introduce themselves.
Good morning, Chair Sullivan and Commissioners. Item number 5 is docket E002/M-24-432 in the matter of, that is the wrong matter name, in the matter of Xcel Energy's petition for approval of a peak time rebate program. The issue before the Commission is, should the Commission approve, modify, or reject the proposed peak time rebate program? There have been 3 filings of preferred decision options since briefing papers were filed. On June 29th, Xcel and Center for Energy and Environment and Fresh Energy filed updated preferred decision options with a few modifications. On July 1st, Commissioner Sullivan filed a set of modified and preferred decision options. These have been distributed, and there are copies available at the side table. Parties are in the room and online, and Kit and I are available for questions. Thank you.
Thank you, Ms. Ricker. We'll start with introductions, if we'll just start. Mr. Schultz.
Good morning, Mr. Chair and Commissioners. Peter Schultz with the Office of the Attorney General, Residential Utilities Division.
Chair, Commissioners, Peter Teglin for the department. I have a number of colleagues online and in the room if necessary too.
Jessica Peterson, Xcel Energy.
Will Nissen, Center for Energy and Environment, and representing Fresh Energy as well today.
All right. Well, we are not planning on opening statements, and I will just, I'll start with questions. I am just curious what the parties think of the decision options that I proposed. I might just start with kind of what I was thinking about. When I've thought about and when I asked Xcel to do this PTR proposal, I was very much thinking that this would be a program that people could use to, really take control of, and participate in emergency events. I think that there are some behavioral programs show real promise that people want to help out. I think that, this is really, during my briefings, Ms. Ricker used the term, this is a carrot-only approach, and I like that. It's a carrot-only approach. And I think that, Connexus has seen a significant amount of success with their program. They use it frequently. They call it multiple times in the summer, and they limit it just to the summer. And I wanted to see Xcel, put their shoulder into it and really develop something that was innovative and, could capture that. And, when I reviewed the record, it captures something similar to what Connexus has done. And when I reviewed the record and reviewed the briefing papers, I didn't feel like what was in front of us was hitting the mark. And one of the things that concerned me the most is that, the existing, Energy Action Days program, which is free and voluntary and relies on goodwill, it relies on people to, to do their part, and is good, but it's basically, I don't know how much I should ask. I mean, how much does it cost OPower? How much do you pay OPower to run that program?
Chair Sullivan, I'm not exactly sure, but
I think but when I looked at it with I appreciate that if you would do that. We're not going to get more performance out of this carrot-only approach where you're actually putting real dollars on because of the, I think the relatively smaller sample size, it's not going to be able to be used with, what Xcel doesn't want it to be used with, the, not AC rewards, but the saver switch. And I just felt like this is just basically going to be for compliance. It's a compliance program. And I didn't feel like what I was hoping for was there. And I do think there's a lot of promise in programs like this. And you do see utilities, Connexus, but not just utilities here, but other utilities around the country running programs that like this that I think work really quite well. And so that's why I, proposed the decision options that I did. One of the things that I was really hoping for is that, and Fresh Energy and CEE, identified it in their comments, is like, I really would like this to be a program that can be relied on as a resource, that reduces the reserve margin, that is something that is included in the resource plan, is something that is stackable, it's a resource, and something that is plannable. Like with Energy Action Days, one of the things that I think in my head is that's not really plannable, that's just the, oh crap, we're in a tight spot, let's just call on the goodwill of Minnesotans, which is good, but it's not plannable. It's like we're not baking that into kind of the firmware of the utility. And that's what I wanted to see with this program. So that's why I feel like it's important to take another crack at this, and that's where my decision options come from. So I've put a lot of my kind of internal meanderings out there for you all to noodle on and judge me based on, but feel free to. Mr. Scholes, if you want to tell me what you think.
Sure, Mr. Chair. Yeah, I think that was kind of the sense that what we were guessing your thinking was when we saw this motion. Certainly understand. There's a lot of uncertainty around like how much customers are going to respond to this and what the benefits are going to be. And I think for that reason, we're more supportive of doing something on sort of a pilot or an initial basis and reevaluate it after a couple of years. Rather than, certainly more record development would be helpful, but we think that could be done after we have some real world data from an initial stab at this. Just because the way we felt in this is we're sort of operating in a vacuum and Xcel has no experience with this kind of rate. So for that reason, we prefer doing something today. Certainly understand where you're coming from and your concerns with this, with where the record's at. But that's why we think sort of piloting this in a sense would be good. I think that there is, indication that this is, the way Xcel designed this, I think is similar to other programs around the country, including Connexus. I think I could be wrong, but I think the incentive amount is similar, like $1 per kilowatt hour. And so we just don't know how customers are going to respond to that. Like I think about like people don't always respond rationally to price signals, and I think about like my own house upgrading energy efficiency. I've spent way more money than I'm ever going to recoup on like energy bill savings, but it's more like for some people it's like the principle. They just want to save as much money as they can. So I think we don't know how they're going to respond to the price signal until we try it.
Mr. Teglin.
Thank you, Chair Sullivan. Many of the department's recommendations over the course of this docket have been in a similar vein to the OAGs in discovering what these values might be, how the accreditation might work, and our initial recommendations continued down that path, including an opt-in and opt-out and Energy Action Days all running in parallel. With that said, we think your motion is reasonable. I think we support it. I think one of the other things that really pushed us over the edge was the recent FERC decision. I'm not a FERC expert or a MISO expert, but our understanding is that that decision made discount residential DR programs, and I think it might be worth taking a beat to develop the program with those accreditation rules in mind.
Xcel.
Chair Sullivan, I think the company supports your motion as written. We can certainly, as the department has noted, take a look at the new rules that FERC has just approved. I don't think you've had a chance to really understand what that will do in the planning year for 2028, and we need to make sure to do that in order to make this successful. We could also offer a small program like we've suggested for PTR to collect data, which is really what we were trying to accomplish, is to understand how customers would react if they are given an incentive or doing nothing. Because my guess is they'd probably do more with their carrot versus nothing at all. But that's certainly up to the commission.
Mr. Nissen.
Thank you, Commissioner. Just wanted to at a high level share your goal in approaching this program of finding resources that can provide value during event times in the best way possible that can offset other investments. We share that high-level goal. We were struggling with the questions that have come out throughout the record that we saw that others have raised as well, and so we've been trying to navigate around all those ideas and thoughts in our head. So that said, appreciate the motion and think it will give us potentially a lot of learning forward and look at different things, particularly in light of the new FERC order approving MISO's changes in their DR rules. So, thanks.
Do any of my colleagues have any thoughts? Oh, Commissioner Hom, and then.
Thank you, Chair Sullivan. Saber Switch, AC Reward, every program has a failure rate, and you calculate that failure rates, and you offer the more dependable capacity to the MISO Module E, right?
That is correct.
Why can't you calculate the same success rate versus a failure rate on this program and offer that capacity? Because you already have a pilot going on. The Energy Action Day is your pilot, right? Even that is worse than this because you are not paying people. You are just telling people you're a nice guy, you do it. But now we are saying that we will pay you. Not only you're a nice guy, but you will be financially rewarded.
Ms. Peterson.
Chair Sullivan, Commissioner Hom, yes, currently we do have the Energy Action Days program. How we analyze savings for that, however, is an average amount. And so we don't look at it by premise or by customer. And so we send out messages, and our vendor currently assumes that value through an average amount. It's something that's other utilities have done, and that's validated through other vendors as well. So we've checked all that data sources. For PTR, however, we would actually look at it at a more granular level by premise. So it's actually more accurate. But we would have to do that by every premise that completes it. I do think we can validate things over time. Power has certainly done it for other utilities, but we don't have that data today, and so I can't tell MISO today that, yes, they're going to get that data every single time because we don't know at this point in time.
So new MISO rule require you to provide individual substation level data, or is it still requiring you to provide NSP load zone data?
Ms. Peterson.
That is a very good question that I don't have an answer to. I don't know.
Okay, so that's why that kind of information is needed. Why MISO rule change is having negative impact to the existing residential program.
From my understanding, and I am unfortunately not a MISO expert, but it is my understanding that they will require specific details to make sure that that accreditation or that load is actually there and is viable. I think they're concerned that people will come to them, whether it's anyone, to say, we have X amount of load, and then it doesn't show up. With programs such as PTR, when we're asking customers to do things, if we tell MISO that they've got a particular amount in February, and that amount changes in July, that could be an issue. And it could depend on what the customer wants to do that day, right? Maybe they wanted to use their dishwasher instead of following our communications, but it is dependent upon that, and so we will need to have data to support it.
No, that's why I was asking you, how granular do you have to go down? Because usually residential program is the aggregate number. Saber Switch, you do not report individual capability. You report aggregate capability based on the failure rates and success rates, and also you are rotating it, so you account for that rotation. So you already have that mechanism built in your calculation of the Saber Switch. To me, it's nothing different. You may have a different failure rate and success rate. And this one, you don't have to cycle it. I think Saber Switch, you promise you cycle it. This one, you don't have to cycle it.
Ms. Peterson.
One of the differences, I think, between Saber Switch and this particular program is one, Saber Switch we control, so we know exactly what we will get. We also verified on a yearly basis to make sure that we are accurately representing what that looks like for MISO. I would assume we would be asked the same type of things for any other type of program, and that we would have to verify those savings.
Okay, so let's say if it becomes an energy product, do we have any concern?
Ms. Peterson.
Can you repeat your question? I'm not sure I understand.
So MISO doesn't require certain demand response product to be a capacity product. They waive most offer requirements. So they call it emergency demand response, EDR. It can become your energy product and critical peak capacity product without capacity accreditation. Do you have any concern using this as?
I would have to call Tom up to answer that question, so I can do that.
Mr. McDonough was moving towards the. You knew you were the person who was going to be accountable for the answer. Mr. McDonough, if you could just introduce yourself for the record.
Tom McDonough on behalf of Xcel Energy. Thank you, Commissioner. Could you repeat the question? I think I understand where you're going.
Since you are here, so what is the new rule? Does it require geographical location report under the MISO new demand response?
Yes, EP nodes will be required. We're working on that. It's very complicated, as you well aware, with the amount that we have, not only for demand response, but also our behind the meter, like solar gardens. And so we're working internally and with MISO identifying all EP nodes. So they're getting more granular, and it's required for the upcoming planning year, but it's very a laborious process for us because of the size of what we must do. The requirements in regards to EDR, I'm not sure if that granularity would be required for this program. And we talked about this in regards to just regular capacity accreditation. That's what you're getting at versus Saver Switch, which is a program we would have to then go through MISO, and they'd have to approve that. And that's a possibility we haven't talked about specifically for this program.
So you say EP node, which is an elemental node, which is different from the CP node. So,
more granular.
So more granular. So as of now, your EP node is a substation level. It's not an individual house, right? Correct. So still you can aggregate behind that substation.
Yeah, I believe 100% that you're accurate going the Saver Switch type of process versus megawatt capacity accreditation like community solar gardens.
Yeah. So still you can do it, but I think that's why I was very disappointed when I was reading your filing and then saying, oh yeah, we cannot do the capacity. And yes, there is a way to do it, but you are not doing it. Second, I think there is a different product you can use you run the pilot if you need to run it, like a EDR. And EDR can be deployed as an energy product. Let's say every time LMP is above 200, you can deploy it, right? Correct. In theory. And then when MISO issue EEA2, which is Emergency Operating Procedure Level 2, and you are telling people anyway, right, at that time to conserve.
That's my understanding.
Rather than you expecting people to react to it, why don't you pay people? That's the whole promise of this promise. In addition to getting capacity credit, this is a time you can deploy it and reward those people doing good behavior.
Yeah, I certainly appreciate the further understanding and where you're going. I think we bring that back and not only consider that, but look at how we can implement a program that would support that. With that said, as in taking that with the spirit it's offered, MISO and the IMM are becoming a lot more conservative on the requirements to qualify as a capacity resource for demand response. And I understand this is different, more granular, so there'll be a lot more proof, and not opportunity, but working with MISO as well as internally.
So when you are developing the record, if we approve the proposed option, can you develop the record on at least until you have more confidence in this program run it as a more EDR-like energy product. Not only you propose as an EDR, but as an energy product. At a certain LMP level, you initiate it and let people to pick and choose whether they can conserve and then get rewarded. And then as a whole system can get the benefit either if you are buying energy from the market, you are lowering buying amount. If you are selling to market, you can sell more to the market. That way, whole system get the benefit of it.
Yeah, I definitely understand the spirit and the logic of what you're saying. The practicality, I would have to go back to obviously the experts, and then the operational standpoint. Yes, we can do things based on LMP. But understanding what the actions of the individuals, that's just like save or switch. We'd have to have more information.
That's why I'm saying that I don't want another filing saying we cannot do it because of this reason. I want to see something more constructive, saying that we can do this much. Let's say if you run this as an energy product and build up your data, then you can be more confident that what capacity we can offer. You can show that data to IMM and MISO. This is our history of this as an energy product. This is our success rate. Why can't you do that way? To me, that's more constructive rather than saying no, because this reason we cannot do it.
Again, we'll work internally to address that. And I definitely can bring back the spirit of what you're asking and support that internally.
No, I mean, eventually it has to be a capacity product. But
yes,
if you're not comfortable, build up the data while you are using this as an energy product.
Right. So I understand. The easy answer is we can't track it today, and so it's not something we can offer to MISO. But when you put in the spirit and the logic of like a saver switch, and we develop the data and the background, it might be something that we can offer as a capacity reduction.
Thank you for that, Commissioner Hom. That was helpful. Commissioner Partridge.
Thank you, Chair Sullivan. I think this conversation does kind of highlight that there's a lot more to be considered. And so I do support your approach of saying, this was a good start. Let's continue to develop this and think about some additional components. I think for me in reading this, my concern is the level of the rebate and whether that's sufficient to really move customer behavior. And I think a little bit different from what I've heard others say is actually I'm concerned that it might be even less effective than the attraction of energy action days, which is, I think there is a psychological component of being part of a bigger system and feeling like you are contributing to, helping out the greater system. I know personally I didn't plug my EV in for a few days this week just because I thought, you know what, I'm going to be fine. I'm not going that far and I don't really want to put any additional strain on the system. I think you remove that with a payment, that feeling of like, I did a good thing. I'm part of this collective system. And for the amount of rebate that you're able to give based on, I'm sure, the constraints of your cost effectiveness test, I just am not sure that's enough to really get people enough of a price signal to get them to move. And so I would hate to see us get rid of energy action days and then find out that that just isn't enough. It was like 50, at max, like 50 cents a month. At today's prices, that barely gets you a piece of gum, So I'm not sure that that's going to be enough. I think in addition to some of the considerations that Commissioner Hom added to the compliance filing for Commissioner Sullivan or Chair Sullivan today, I would like you to look at opportunities to just consider and evaluate what it would be for you all to run the program internally and whether that might allow you to shift some additional program costs over to the customer side to provide a more significant rebate. Perhaps there are some opportunities to leverage the different types of DR within MISO to allow you to maybe put a little bit more of a rebate to customers. I just think and I don't know if we need to include it as an additional item here, but I was just hoping that we could see an evaluation of opportunities to reduce the vendor costs as a proportion of the total program cost and to put more money towards the customer rebates. You know, in my mind, I was thinking O-Power, it's probably not the case that O-Power's costs will scale with each additional customer. So maybe if you had more participants, that could be a way to do it. I don't really have the answer for you, but I do want you to consider ways to provide more of a benefit to the participating customers. I have one more thing that I just wanted very in the weeds note. I also support decision option 30, which would give us some more information on how DSM bundles in general work within the IRP modeling. I just wanted to make a note that it is my understanding that the Encompass model is not particularly well suited for certain types of DSM, particularly energy efficiency, which is a cumulative resource that sort of grows over time, as opposed to a supply side resource where you get all of the megawatts you need as soon as that project comes online. So it's a bumpier resource. And so I just want to give you verbal encouragement to consider and discuss the flexibility that you need, because I know there's some work that you have to do on the human side still. We still have those that work outside of models to improve them, in case any tech companies are listening. And that, you know, I want you to feel empowered and encouraged to provide that nuance, because I know that if you just strictly discuss when the Encompass model selects a DSM bundle, it's going to lose a lot of the important nuance that the Encompass model doesn't have the ability to consider in its decision making that you all do on your resource planning team and the DSM team to make sure that you're getting that cost-effective energy resource and maximizing that within the IRP model. So I hope that makes sense to you, Ms. Peterson. I'm assuming it does, because you've been doing this longer than I have. That's all. I support your approach.
No, that's also very helpful. I appreciate it. Commissioner Tuma, are you, do you think we need a minute or two? Are there the thoughts that you've shared with us, do you think that they are encapsulated in everything that's here and it's just kind of additional food for thought for Xcel and the parties? Or is there something you want to memorialize in a decision option? And I'm asking both of you guys.
I'll just ask the company, do you feel like it'd be helpful for us to write down the piece that I offered, which is just, is there a way to make that rebate bigger for the customer and perhaps reduce the vendor side?
I don't think you need to change the order. I can certainly do that.
I feel comfortable. I verbaled it. I recently learned that can be used as a verb.
I verbaled it.
I verbaled it, so I think it's good.
Better than oral, I like that.
Yeah.
Commissioner Hom.
Thank you, Chair Sullivan. I think I told enough. I think every party, the bottom line is be constructive. Rather than looking for reason to say no, find a way to deliver. I think that's my message there. And I was suggesting one way to do it using MISO rule, but there might be a different way to do it, because even as a capacity product, because it depends on how you use the statistics to deliver the capacity. And I don't think that MISO and IMM is completely saying that you have to have 100% reliability. No generation has 100% reliability. Every power plant has a failure rate. So that's why its verifiable failure rate is probably acceptable, and then we can discuss that in different venue. But I think that's why you have to find a way to do it rather than looking for reason to not to do it.
Yes, Mr. Tieglin.
Thank you, Chair Sullivan. The department is interested in Commissioner Ham's line of questioning about the EDR as an energy product and wonder if there might be a modification of Sullivan's proposed modified 28 to include in that compliance filing perhaps language like the results of the company's evaluation of whether the PTR program or EAD program could be offered in MISO as an energy-only emergency demand response resource.
Commissioner Hahn.
Thank you, that suggestion. So my suggestion was 2, energy product if LMP is above certain threshold, second, and offer that as EDR during the emergency. So it's a 2 different component. That way we can bring more money to the participant. So that's why.
So then I just want to make sure that we're getting this in terms of changing that this would be modified 28A. How would you recommend, Mr. Tiglin, that we change that? The results of the company's evaluation of whether the PTR program.
Sure. You could add a sentence after the last one there. The results of the company's evaluation of whether the PTR program or EAD program could be offered in MISO as an energy-only emergency demand response resource when LMP prices are above 200 megawatt or $200 per megawatt hour.
So I'm not setting the $200. So you guys need to figure it out. I'm just giving you some potential benchmark. So you have to see annual pattern of the LMP and what is the Xcel's fleet position at the time, and then what is a potential return to it. So it's not as simple as I said, but I think at least I was suggesting that we should find a way to deliver this rather than say no to it.
Staff has developed some language that we could just quick flash up that I think captures this well, and I know exactly where you guys are going, and I think that this is a good addition. So Ms. Ricker is. To the company Ms. Peterson, the language that's coming up here, you see where we're going here? Not yet.
I can't actually see. The company is good at that language.
You're good?
Yes.
Commissioner Hom, we're squared away?
Okay, once again, I do not really focus on individual language, but you already capture my intentions. So as an energy product, you don't need to register at the MISO. You just not consume it. And then you have a saved money or extra revenue from it. However, you have to register as an EDR for the EEA2 deployments. So 2 different things. So I was suggesting 2 different products for this program. So every day you just check the LMP, if price is up, you use as a regular conservation. And then during the EEA2, which will give you a lot of revenue from it, also plus it gives you reliability, additional value to it. But you don't get a capacity accreditation, you are not required to offer that product every day.
Chair.
Commissioner Partridge.
After listening to Commissioner Hom, I don't think this language captures what you're saying. I wonder if we want to include it. Could we take 5 minutes? And
Yeah, let's do that.
I don't think this is right.
Yeah, let's take
Okay.
a couple minutes. Okay. I'm a little concerned too, so I'm glad you verbalized it.
Thanks. I'm here to verbal.
All right, are we ready? All right, Commissioner Partridge, share with us what.
This is my interpretation of the conversation that we just had, which is that in addition to the other items that you've asked the company to include in a compliance filing, we would also ask them to consider additional value streams, which would include, one, the ability of the PTR program to offset energy costs during high LMPs. And that could be done completely outside of MISO and would likely flow through the fuel clause to show savings to customers. Two, as an EDR product, which would be through MISO. And then three, and this gets at what I had said as well, are there any other ways that PTR could provide additional value streams or financial benefits to ratepayers that we could then use to improve the participant rebates, which would then potentially continue to grow that overall resource. I will ask Commissioner Hom, do you think this gets at what you were saying?
Commissioner Hom.
Yeah, thank you, Chair Sullivan. Yes, I think it captured those two. I think 1 and 2 as a separate item. I think hopefully that is a common understanding, all parties, to make sure that we are pursuing this. Thank you.
Would you say that it captured it beautifully? I'm just kidding. Just kidding. You guys, it is very close to vacation time for all of us, and so I apologize that I've been a little bit goofy today. Yeah.
I get it. Does anybody have any additional thoughts? Mr. Nissen, CEE, Fresh Energy, good?
This looks great, appreciate this, and just, even though this discussion, these items are focused on PTR, we think this will be helpful learning and evaluation across other DR products and ideas too, so hopefully very helpful discussion here.
Thank you, and one of the things that I just do want to call it out in the motion is under modified 28, Xcel must consult with stakeholders, including commenters in the docket and others with relevant experience. Because I know you will do this, but I think, I very much appreciate the community of advocates and folks in Minnesota, many of whom have really good ideas, and we can work towards, something that I think would really be a great program, that so I'm any other thoughts, Mr. Teglin, Mr. Scholes, or
the department appreciates the effort that went into this, the thoughts that generated it, and the wordsmithing to our half-baked addition to that DO. Thank you for fully baking that cake.
Mr. Chair, the OAG appreciates and understands the new decision option based on Commissioner Hom's ideas, so we appreciate that and look forward to reviewing that.
Commissioner Partridge?
Chair Sullivan, I did want to say, I do really appreciate the OAG's discussion on communication and marketing. I think that was a really important part to dig into, and so I hope that the company will carry that contribution from this docket forward into the next proposal, and that Mr. Schultz will continue to push on that, because I do think, given there are limited funds for us to provide rebates to customers, and that marketing and communication is going to be absolutely critical to supplement whatever rebate levels we're able to put towards customers to encourage participation. So thank you.
Ms. Peterson?
I appreciate the changes, so thank you very much for adding those. And I think this is something the company can certainly do, so thank you.
Thank you. All right. The motion then will be my preferred decision options, the pre-filed decision options, with the changes that Commissioner Partridge and Commissioner Hom have made to Sullivan Modified 28. Well, before I go, that's my motion. We're clear on the motion, right? I'm going to go back to a question, though. Ms. Peterson, I had asked you about O-Power, and I'm wondering if you guys had the cost to run the Energy Action Days today.
Thank you, Ian Dobson for Xcel Energy. Thank you, Mr. Chair. We have that number. What I don't know yet. Once I heard cost with a vendor, my mind goes to is this trade secret? Is this negotiated? So we're trying to figure that out. And we're happy to file something, and obviously if it's public, we'll file it publicly, but we just need to figure that out, but we can certainly get that information to you.
Got it. Okay. That's just, okay. Thank you. With that, is the motion clear? Mr. Whitty, motion clear?
Please restate it one time.
So it will be my preferred decision options with the changes that have been included to Sullivan Modified 28. The Partridge Hom changes to Sullivan Modified 28. And just to be super clear, so that will be Sullivan Modified 6, Sullivan Modified 28 as further modified by Commissioner Partridge and Commissioner Hom, and Sullivan Modified 29 and Decision Option 30. Mr. Nissen.
Just decision option 19 was included in your filed set.
Oh yeah, decision option 19. Thank you. Thank you. That's important. All in favor, please say aye. Aye. Opposed? The motion passes. Thank you, everybody. I hope everybody has a nice 4th of July and that you come back with all of your fingers. So. Yes. 250 years.
Bicentennial was much more easier.
Bye, everybody.